State versus Gilmore.
Yes.
Do you have anybody coming, or can we proceed?
Proceed. I believe the other side has waived as well.
Yes, that is true, so you'll have to once again.
Thank you. And this is the case of State versus Gilmore. May it please the court, I'm Alan Medvick. I'm here on behalf of Mr. Gilmore. We are appealing the court's denial of Mr. Gilmore's suppression motion. This has previously come before the court, at which time this court ruled in Mr. Gilmore's favor regarding the issue of this not being a consensual encounter. We are here to address the second issue, which is court remanded, which is whether there was probable cause for an investigative stop. We obviously contend that there was not. Briefly, I would like to address the state's argument that the law of the case doctrine does not apply and would allow, when this was remanded, the trial court addressed the issue of investigative stop, but also went beyond to readdress the question of a consensual encounter. I think the law of the case doctrine pretty clearly applies here. There was no new evidence argued, nothing that would even open that up for further discussion. This court has ruled, and the trial court would be bound by that ruling. So I don't think that is an issue up here on appeal. I would just leave that to the court to consider. But more importantly, the investigative stop based not on probable cause. Mr. Gilmore lived at 24 Oakdale and had left his house and was walking down Oakdale when he turned around and went back into his house and to retrieve his cigarettes that he'd forgotten, and then walked down the street. The police officers who testified characterized they have characterized this as an attempt to elude the police and basically avoid confrontation, which they considered to have been sufficient probable cause to proceed on the investigation. As they describe it, Mr. Gilmore saw them and turned around, and then they followed him, or they didn't follow him directly. They turned down a parallel street and cut back, at which point they did not see him until he was on Market Street, much further down the road in the direction he was originally traveling.
But he didn't then just turn around and go back into his house?
His house was essentially one house up from where he was. He went back in, grabbed his cigarettes, and then started back down the road. Obviously, I, as trial counsel, didn't put Mr. Gilmore on. I apologize, that's not information in the record. But it's also, what is in the record is Mr. Gilmore lived at 24 Oakdale, which is the residence directly behind, maybe 2 houses behind the Baja where he was seen walking down the street. And then he turned around. That is the extent of the police testimony. That's what they know. And then they saw him again walking down Market Street at Market and North, which is, they describe it as about 100 yards away. And they stopped him at that point. They asked him what he was doing there. He stated he lived at 24 Oakdale. He asked them why. The police asked them why he was avoiding them. He stated, I was not. I lived at this house behind. At that point, whatever suspicion they have, I think, was allayed. I think that the 9th District in Ohio law is pretty clear that when you have a clear explanation, when you have reached the least intrusive point and you have no further point to proceed, your questioning has to end at that point. So even accepting the officer's testimony that having gotten those answers, they then proceed to ask Mr. Gilmore if he had any drugs on him, was beyond the scope of their investigation at that point.
Can we address that as it relates to this court's finding, and the state's conceded, of course, on remand, that the stop was not consensual? So
Okay.
if the stop is not consensual, how does that impact the necessity of Miranda warnings before they asked?
I think they would be required before they ask, and I think it would be construed as, to that extent, and I think Ninth District case law is clear on that. And I apologize, and I think there's a recent ruling out of that court, out of this court in that regard, on very similar grounds, that a non-consensual stop would require a Miranda warning before you ask incriminating questions of that nature. And I apologize, I don't have that
No,
case
that's
caption. And the other part of this that I would like to address very briefly is that in the record and in the appellee's brief, they make note of the police stating that Mr. Gilmore was some 100 to 120 yards away in about 20 seconds. I think that at the same time, there's also evidence that he was not winded at that point. He was not, there was no evidence that he was running. He was walking at a normal pace when they saw him. The math on that does not add up in two ways. One, to have covered that kind of space would be to be moving at about a 5.5 minute mile. So that for Mr. Gilmore to have been moving, which is an incredibly fast pace for a person to be walking, the idea that he would have had to have been seen to have been sprinting almost from the minute that started. The other aspect of that breaks down, I'm sorry.
I'm just thinking 5.5 minute miles, what you said, I'm trying to do math.
And that's a pretty good pace. It's incredible. The other part of that is that the description of how the officer drove their vehicle, having seen Mr. Gilmore at Oakdale Street where they were sitting, and then pulling out, going down Ball Street, cutting through an alley, cutting back down Oakdale to see him some 120 yards away. For them to have made that distance, they probably would have been traveling about 160 miles an hour. So I don't know that those times at that speed line up for anybody. I think that calls into question the probable cause. Slowing that down to a more reasonable rate for the police gives Mr. Gilmore considerably more time to have engaged in a normal, non-criminal activity, given that he lived in the residence right behind. I think that there's insufficient claim of probable cause. I think that...
Or are you talking about probable cause or a reasonable articulable suspicion to stop him?
I think those are interchangeable. They need to have a reasonable suspicion to make the stop here, and I apologize for that, yes.
It seems, as I read the decision, that the issue of consent creeps back into the analysis with respect to the Miranda.
Yes, I believe that you're right there, that I think the trial court did, having reached the point where there was no consensual encounter here, which we have to accept on this appeal.
No consensual stop.
No consensual stop. That the trial court seemed to intimate that by answering that question of do you have any drugs on you, he was essentially consenting to that. And I don't think he has a right. I don't think that is, I don't think he can do that without having been advised of his Miranda rights first.
What if he's not stopped? What if they haven't stopped him and he's walking down the street and they yell, do you have
Yell out
any
the window,
drugs
do you
on
have any
you?
drugs on you?
And he says, yes, I do.
I think at that point, but that's not our situation.
I understand that,
But if someone were to yell out the window, do you have any drugs on you? and that person were to say yes, to a police officer, that would probably then give, I would say they would have reasonable suspicion for the stop at that.
They don't have to say, you have the right to remain silent, as they're yelling out the window, they don't have to say, you have the right to remain silent, give the whole Miranda warning, and said, do you have any? I mean, let's assume for a minute there's no stop, we know there's no
In a-
consensual stop.
I think you are to be, as a police officer, you're to be as, the least intrusive possible remedy, if possible encounter is what you're going for. So if you, even beyond that, if you were to stop someone who had a flat tire, that does not open you up to the right to just ask them if they have drugs on their person. If they simply are stopped at the side of the road, they have a flat tire, you can ask them that question. At that point, they're not in an investigative stop. And I guess if they answer that question, yes, that's a consensual encounter. And we run into that all the time, the plain view encounter, where.
So once he's subjected to a non-consensual stop,
I think at that point, we have gone, in this case, we had a non-consensual encounter where they had reasonable suspicion, where they claimed to have reasonable suspicion, which I believe they don't from the word go. They asked some questions which remedied, which should have remedied their suspicion. He lived close by, he was not avoiding them, not when did all of these things apply. Beyond that, he, at that point, when they understood that he was not committing a crime, that they went on from a stop that they initiated, and that they initiated solely to investigate this issue. This was not a person, who called the police. It was not, he didn't have that flat tire and say, I need help. It wasn't an auto accident, it wasn't some other encounter where he had recently been. And in those questions, the essence of a consensual encounter is you have a right not to answer the question, you have a right to simply ignore the police. And the police officers here indicate that, I think Officer App.No stated that he was not free to leave, that Mr. Gilmore would have been detained if he had simply said, no, I'm not going to answer your questions. That was there. This was beyond a consensual encounter and not a, it had reached a point where he was detained. And I think at that point, he's not just driving down the street screaming out the window, do you have drugs on you? He was in fact stopped and asked very specifically by a police officer, with an expectation that he was not free to go. And so I think that is the separation. I believe if the court has no further questions, I can see that.
I don't believe so.
All right. Thank you very much.
Thank you. Thank you, counsel. The court will take the matter under advisement. A written opinion will be sent to you and to the prosecution, as well as we'll release our electronic copy online.
I appreciate it. Thank you very much.
Have a good day.